Hello, everyone. My name is Akira Inoue, a U.S. litigation partner at the Baker & McKenzie Tokyo office. What is the motion to compel and in the U.S. litigation, to which extent personally identifiable information would be protected? The big issue for Japanese clients. To deal with this important question, today we welcomed two of our really real experts from U.S. offices, Barry and Brian. Welcome to this video lecture, Barry and Brian. And first question to Barry is, what is the motion to compel and when it is used in U.S. litigation? Barry, would you kindly describe your response to the first question, please?
Sure, Akira. Thanks very much. It's a pleasure to be with all of you. So what I'm going to do to help you understand the basics of a motion to compel and how one would come to deal with a motion to compel is to tell you just a little bit about our discovery process. So in the U.S., as I'm sure you're aware, we have very broad opportunity to ask for documents and information in our discovery in litigation. And so how does it happen? The first thing that happens is you get a written request. And in this case, we're talking about documents. So let's call it a written document request for certain types of information from a company in Japan. The company then gets to respond and object to those requests. And those written responses get sent over to the other side. And the other side will then evaluate and decide if they can accept and live with what the company's agreed to produce, or if they are unhappy with the extent of the production that's being offered. And if they are not happy with it, then we start what's called a meet and confer process, where the parties counsel get together and they try to work out an informal arrangement. We're here today and we're going to talk about privacy issues. So we're going to assume that an agreement can't work out, probably because of a lack of consent from some of the parties involved. And so the next step in the process would be that the party that propounded the written discovery would be filing a written motion to compel production of those documents. That is usually about a 15 or 20 page written pleading that is filed with the court that's sitting over the matter. It could be in state court or it could be in federal court. And the goal of the person who files that motion is to force production of the documents by way of a court order. And we go through a briefing process. Both sides get to brief the issue, and then ultimately we'll have a hearing and argument in front of the judge, and the judge will render a decision, some type of order relating to the discovery dispute. So that's really how it works. That's where you run into the context of a motion to compel, and you have to deal with what comes out of it, possibly in order that you are being compelled to produce documents.
Excellent. The next question is, any exception to court order in response to motion to compel in Japan? Privacy and personally identifiable information is regarded as quite an important one. And many of the Japanese companies, those information, privacy related or personally identifiable information should be regarded as exception. Would the party be allowed to reject to produce a document or more broader term information on the privacy and personally identifiable information under U.S. court proceeding? Barry, would you kindly share view and response to this question?
Happy to, Akira. And this is going to get me into the area of expertise of my partner, Brian, who is a privacy lawyer. But the way it would work out in U.S. litigation is as follows. When the document requests come over to the company in Japan from their U.S. counsel, almost surely the company would raise as an objection the privacy laws of Japan and argue that this is a reason for non-production of the documents that are being requested. That issue will get litigated in front of the judge, where, again, whether you're in state court or in federal court, and ultimately the court will make a determination of whether under US law it can compel the company in Japan to produce these documents in litigation. Brian and I were talking about this before this presentation, and we both are of the view, and Brian can speak in some detail about this, that most US courts are unsympathetic, for lack of a better term, to privacy laws from, be they from Europe, be they from Asia, wherever. And oftentimes we will find that even when those objections are asserted, privacy and other objections, US courts wanting to give broad discovery to the parties to litigation will overlook those or will overrule those objections and order production of the documents, even in the face of those types of objections. And even knowing that in a place like Japan, there is a risk of criminal punishment for someone who ignores privacy law. So it really is subject to the court's determination and the scope of how the court writes its order on this motion to compel.
Much appreciated, Barry. It's a sort of a conflict between US law and also Japanese law. And under Japanese privacy and personally identifiable information protection rule, in order to surrender those type of information, the consent from that owner need to be secured. This is in essence the rule of thumb under Japanese law. And if we are unable to get a clear and unequivocal consent from that owner, is it a legitimate ground to refuse, totally refuse to surrender those information to the other party and under the U.S. litigation rule? Brian, would you kindly share your insight on how we should think about this issue?
Akira-san, so good to be with you, and Barry for this. At a high level, there are three different types of regulations that you have to deal with locally. The specifics vary by country. So certainly in Japan, we have a personal information protection law. Many jurisdictions around the world have those now. Those laws apply to, as you had said earlier, personally identifiable information or information about individuals. Typically, they're very broadly applied to something as simple as name and contact details can be personal information under most privacy laws. Depending on the jurisdiction you're in and the context, we might have other types of local data restrictions. So bank secrecy, professional confidentiality. These can be industry-specific rules that protect, customer data or patient data or otherwise. The customer and information can be legal entity information, not just individual. So that's another aspect of it. And then a third category is, I'm going to call it a catch-all category of blocking statutes. These are in places like France and Switzerland and British Columbia and even China to a certain extent now. These are laws that prohibit doing anything in the local territory that would aid either a foreign court or a foreign government in doing anything. So that's not at all limited to just personally identifiable information. It's really any information. You can't gather any data. So there are these three types. The privacy one, which is the one, Akira-san, you had mentioned, is probably the most prominent or most frequently encountered, which is when that production that Barry had mentioned in response to the order would contain data about individuals. The specifics on what you would need to do to solve that local privacy law vary. In some jurisdictions, it can be that a consent would be needed from the individual. In other jurisdictions, it would be that you needed to give the right privacy notice and you have the right, say, model contract terms to protect the transfer of data and the disclosure of data, et cetera. But very often, as you alluded to, in practice, it's maybe very difficult to actually get consents or to really do the privacy compliance perfectly. And so then you're in a situation where typically the company has to balance the different obligations, because to be clear, Barry mentioned that the courts in the US are not sympathetic to the privacy issues. Well, guess what? The privacy authorities in non-US jurisdictions are not sympathetic to the US court process. In fact, if anything, they're antagonistic towards the US court process. So if they find out about disclosures of data, they may not be very happy about it. So really, the company can often need to balance two different sets of requirements that even directly conflict, and resolve that in favor of which side are you most worried about? Are you most worried about the impact in this litigation, or do you feel like you've mitigated the privacy risk, or are you most concerned about the privacy risk and you'll take a hit in the litigation? So there's often not a one-size-fits-all answer to that question.
Excellent. To balance two different risks Japanese client will be facing. One is risks in connection with local authority. That one side, and another side is of course a U.S. court, and so assuming that the consent is not secured, even if our client would try very hard to secure the consent from that owner, unable to get the consent, and under that situation, and also court would not allow the exception to refuse to surrender personally identifiable information on the ground that the client would unable to get the consent from that owner, but still would like to refuse to surrender that information to the court. Technically speaking, this is a refusal to motion to compel the court order. Under that situation, what would be the legal risks in refusing the court order of U.S. court? Barry, would you kindly share insight on this?
Yes, thanks, Akira. That's a really good question, because you posed it absolutely correctly. And you have to, this is the balancing that Brian's talking about. And on the one side, the litigation side, you have to decide what is going to be the effect of what we would be calling violating a court order. Because if the court is ordering you to produce the documents, you don't produce the documents, you are now in violation of a court order. It's frankly something that us litigators and trial lawyers live a little bit in fear of, because we find ourselves somewhat at the mercy of the judge, and the judge has a wide array of what we call sanctions that can be utilized to try to compel you to comply with their court order. Generally, what they're supposed to do is they are supposed to start with the least punitive type of sanction possible, and then move in an order. I guess it would be an ascending order of severity for sanction. So it would probably start with a monetary sanction if you violated that order. They may charge you not only for the time necessary to bring the motion to compel, but also some daily sanction amount for failing to provide the documents that can run somewhat indefinitely. If that is not enough to bring you into compliance with the order, you continue to be in violation, the court really has a lot of latitude to raise from that monetary sanction and go to maybe evidentiary sanctions. Say you're the plaintiff in a case, you and I have a case on US type courts and arbitration process where we are going to want to put in particularly good evidence on behalf of our client. Well, the court could decide it is going to bar you from admitting that evidence, that important evidence. That would be a second level type of sanction. And it gets worse from there. If you're in violation and continuing violation, it could be what we call an issue sanction. You might not even be allowed to address a particular issue by the court, and it can get so severe. If you continue to graduate up to the next level, it can be dismissal of your action or entry of judgment against you. So, this is that difficult balancing you have to do on the US side of litigation, because, courts do work, they're very stringent about wanting their orders to be conformed to and agreed with. And again, we have a very, very giving discovery process, a very broad discovery process that US courts think must be respected in order for litigants to get justice in our system.
Excellent. Thank you, Barry. So what our clients should do in essence, as you have correctly described, on one hand, the risks in connection with refusal to surrender document and by ignoring motion to compel is huge, including monetary sanction and other type of sanctions that are huge risks. But on the other hand, risks in connection with the violation of privacy law and personally identifiable information protection law in Japan is also a bit of risks, including criminal sanction risks. And given two conflicting issues at both ends, how to effectively deal with, how to solve this conflicting situation? Any practical advice from your perspective? Brian, would you kindly share your insight on this?
Yes, of course. Thank you, Akira-san. So a great question. The answer is you really want to look case by case and figure out what the right answer is for that case, or the least harmful answer. And so you need to look at things like, well, how relevant is the personally identifiable information that's in these documents? Is it kind of irrelevant, such that maybe we could redact the names and the other side won't even care because it's not relevant to what they're doing. They're more interested in the content of the documents. So start there. Look at other factors. On the flip side, how much personally identifiable information would we be sharing? How sensitive is that personally identifiable information? How upset would the individuals to whom such data relates be if they knew that their data was being part of this process? Sometimes with commercial litigation, it doesn't even matter because the individual is not even really at issue. It's their name is on a document. They don't care. But you need to evaluate the sensitivity of the data. How likely is it to upset the individuals? How likely would a foreign privacy authority be interested in this versus what's the impact on the cases? And you can also sift and look at even more details. So for example, when you get down past the privacy into even the blocking statute layer, if this data, we had a bank one time that was responding to process, and it was a global bank, but the data was already sitting in New York on servers. And the judge is saying to us, look, the data is here. You're not going to violate the French blocking statute because the data is here. Or if there is a violation, it's already accrued to you because you got the data here in the first place. Anyway, so sort of where the geography of where the data is, are we having to pull it from the local jurisdiction, or is it already here? These are all factors that go into trying to balance and then looking carefully at what Barry had said, which is what is the impact on the case side versus the specific legal implications on the local side. So no one size fits all answer. We really need to be thoughtful.
Excellent. Thank you, Barry and Brian. And Barry, would you kindly share your insight on this?
Sure, Akira, happy to do so. All great points by Brian. It's really nice to see, to hear a colleague that is very pragmatic about all this, and Brian is clearly that. One of the things that I think companies have to consider in this process, when we're balancing the privacy interests versus the litigation interests, absolutely what the company would want to do is fight the motion to compel hard. right? Assert all these objections. This, oftentimes in litigation, we don't really like to have the issue go all the way to decision by the court on a discovery issue, because sometimes there are discovery sanctions issued just in opposing a discovery motion, like a motion to compel. But here I think that you have to run the risk of that, because if a Japanese company is trying to decide, are we going to make the hard decision to produce this personally identifying information, you absolutely don't want to do it, quote unquote, voluntarily. You would do it under compulsion by a court, so that sets your defense up better vis-a-vis the Japanese authorities. And so if the court is ordering you in the US to do it, you have no choice but to do it, then your position in Japan is probably strengthened by that, right? The other thing that I think, Brian kind of was hinting at, and that you might use in that meet and confer process that we take part in before a motion to compel, is his suggestion about agreeing to redaction of the documents is very pragmatic and appropriate, right? I mean, I could in the course of a meet and confer with the other side say, we have a challenge, we have a privacy statute in Japan, we will agree to redact all this stuff is going to be redacted. It's not germane to our dispute, because this is, as Brian suggested, a commercial litigation matter or something that doesn't deal with these particular individuals. I would want to use that in the negotiation process as well, because that's a bonus for us, and it would show the Japanese authorities that we've been trying to protect personal information. You still might need to let it go all the way to a motion to compel and an order, so you have that additional layer of protection, of being compelled by the US authorities to provide the information. But that's a way that we've managed it in the past with Japanese companies, is we have made sure that it goes all the way through the process. We assert all the relevant objections. The court makes the final decision, and then the company, in conjunction with Baker McKenzie, makes the decision about what to do next and where to put the documents or not put the documents.
Excellent, Barry. And it seems like, given the complexity of this issue, when facing this issue in a real case, I need to consult with Brian and Barry at the same time to get the advice.
I think that sounds
probably that's the shortest answer to deal with this very, very complicated issue. But anyway, thank you for sharing your great insight, Brian and Barry. That's very helpful and also quite much insightful to Japanese companies. Much appreciated.
Absolutely.
And also, thank you for attending great audience. And we hope that our discussion will be helpful for you to deal with this complicated issue. And please stay tuned with Beck and McKenzie. We will be providing more insight on the US litigation. And see you next time. Thank you very much again.